Welcome to the committee, and please state your name.
My name is Nick Dumas, and I'm here representing Integrity Idaho. Mr. Chairman, members of the committee, thank you for taking the time to hear this important legislation. As I said, I am Nick Dumas. I'm from Nampa, Idaho, and a resident of District Number 13. I am the co-director of Integrity Idaho, a member of Integrity USA. Integrity is a fellowship for gay, lesbian, bisexual, transgender persons and their allies within the Episcopal Church. Integrity Idaho represents the Diocese of Idaho regarding GLBT issues, and with the blessing of Bishop Brian Thom, who is with us here today, and on behalf of Integrity Idaho members and the Diocese of Idaho, I speak to you today. Ladies and gentlemen of the committee, I speak in favor of House Bill 2. Members of Integrity Idaho firmly believe and strive for inclusion and protection of rights for all persons in our parish churches, diocese, and our communities. The Idaho State Constitution, Article 1, Section 1, clearly states that all men are by nature free and equal and have certain inalienable rights, among which are enjoying and defending life and liberty, acquiring, possessing, and protecting property, pursuing happiness, and securing safety. With the current wording of the Idaho Human Rights Act, this constitutional promise is simply not being fulfilled. Many of our GLBT brothers and sisters live in constant fear of losing their jobs, being denied housing, refused services, or even facing violent acts against them. It is imperative that we all work diligently together to ensure that all of Idaho's citizens are assured our constitutional promises of life, liberty, pursuing happiness, and most importantly, securing safety are ensured. Now I speak for myself. I am a proud gay father. I have a beautiful 12-year-old daughter who is growing to be a vibrant, open-minded, and very lovely young lady. I've always taught her that all people, regardless as to who they are to be treated equally and with respect. I want her to be proud of her home state of Idaho. However, with the current status of our human rights law, it's hard to do that. Idaho is simply too great to allow disenfranchising behavior or speech hurt her citizens. To not amend the current law would be the equivalent of posting signs at our borders, simply stating you're not welcome here. This would be a travesty, as everyone should be welcomed equally within our beautiful state. Help us build a state that our children and grandchildren can be proud of and feel safe in. As men and women of faith, we have a responsibility to ensure that everyone can feel safe to be who they are without fear of being ostracized. We are commanded to love our neighbor, and that means everyone, without regard as to how they might identify themselves. We, the members of Integrity Idaho, and myself as a citizen, call upon all Idaho legislators, regardless of party affiliation, to add the words sexual orientation and gender identity to the Idaho Human Rights Act. We call upon the legislative bodies to pass this legislation with great haste. All of Idaho's citizens deserve every protection possible. Passing an equal protection statute is the right and just action to take. It is our hope and prayer that very soon all citizens of our great state will have and enjoy equal protection, and that our GLBT brothers and sisters will no longer live in fear. And most simply, it is just the right thing to do. Pass House Bill number 2. Thank you.
Are there questions? Seeing none, thank you, sir.
Thank you, Mr. Chairman.
May Rude, followed by Robert Spiel, and following Robert will be Julie Stratton. Welcome to the committee. Please state your name and who you represent.
Hello, my name is May Rude. I'm a private citizen from Pocatello, Idaho. Mr. Chairman, members of the committee, I'm asking you to add the words sexual orientation and gender identity to the Idaho Human Rights Act because as a transgender woman, a lesbian, and a proud lifelong Idahoan, I just want to feel like I have a real chance at having a long, happy, and successful life here in Idaho. In a practical sense, this move will have a real impact on making sure that the many LGBTQ Idahoans will be legally assured a fair chance at the same quality of life that other Idahoans have. The National Center for Transgender Equality says that 1/5 of trans people have been refused a home or apartment, and 1/10 of trans people have been evicted from a home or apartment because of their gender identity. Additionally, the National Transgender Discrimination Survey, one of the largest surveys ever done on the subject, shows that 90% of respondents reported harassment on the job, and 47% of respondents had been fired, not hired, or not promoted because of the gender identity. This is a serious issue that affects many people. But it's more than that. It's also a symbolic move that will show LGBTQ Idahoans that our state sees us as being equal to everyone else from our state. It's hard not to have your basic humanity recognized by your own home and by your fellow Idahoans. And really, that's all we want. We're asking for so little, just the acknowledgement that we are human beings and that we deserve the same basic human rights as everyone else. The knowledge that my state and my government refuse to protect me or really even acknowledge my basic humanity was one of the things that kept me in the closet for so long. I was afraid that as soon as I came out, I would lose my job, I would not be able to find a new one, that I would be denied housing, that I would have just no way to live a normal life. And because of that, I started to lose all hope. Staying in the closet caused me to fall into a deep depression that peaked with me standing in front of my bathroom mirror holding a handful of pills ready to kill myself. That same study I talked about earlier by the National Transgender Discrimination Survey found that 41% of trans people have attempted suicide in their lifetime. I was lucky. I'm still here, and I was able to finally see a glimmer of hope and a better future for a trans woman like me. However, many LGBTQ people don't see that future. We can look to examples like Leila Alcorn, a 17-year-old trans girl in Ohio who looked at society around her and tried to find a good future, but didn't see any way that she could live successfully as a trans woman. So she took her own life at the age of 17. It's our job to make our world, our country, and our state a better place for all the other Leila Alcorns out there. We need to ensure that people like her, people like me, and people like all those you see here testifying in favor of adding the words gender identity and sexual orientation to the Idaho Human Rights Act have a bright and safe future here in Idaho. A future that offers security, opportunities, and a fair chance at a good life. We already have so much going against us, we don't need our own home state to go against us too. So that's why I'm asking that you add the words to the Idaho Human Rights Act. Thank you.
Are there questions? Seeing none, thank you. Robert Spiel, followed by Julie Stratton, and then will be Ken Connolly. Please make your remarks as you continue to testify. We've got an awful lot of people signed up to testify, so be as brief as you can and to the point, and try not to replow too much. Mr. Spiel.
Thank you, Mr. Chairman, and members of the committee. Thank you for your careful deliberation over this matter. These are things that really are of great significance in the state of Idaho and throughout this nation. So thank you. My name is Robert Spiel, and I stand here as a citizen of the great state of Idaho. And I respectfully ask the members of the committee to vote no on House Bill 2. But I do so understanding the ramifications of saying that. You see, this law will not create the equality in our society it claims to seek. And I say that with respect to all people of Idaho. One of my brothers is gay, and one of my very best friends is also gay. We have very strong relationships. I love them. I want only the best for them, and my feelings run very, very deep in regards to rights for all. At its face, House Bill 2 appears to be a worthy cause for the intention of promoting greater understanding and acceptance in our community for all of its citizens. It is only when we look deeper, however, into the sad but true unintended consequences of a measure such as this that the societal impact of the law becomes extremely clear. Indeed, we need look no further than the states around us to see the full extent of how these unintended consequences have played out in other communities. For instance, as was made law in California 18 months ago, under HB 2, students may choose their gender based upon their sole and individual perception. And under enforcement of that law are then given free access to bathrooms and locker rooms of the opposite sex. Therefore, any male can follow a teen or younger female into a bathroom and not be questioned. I realize that that's a difficult scenario to even imagine taking place. But I'd like to ask, how many middle school and high school teachers would we lose who do not want to be faced with the choice of walking into a bathroom to see what is going on or not? I've heard it said such a thing would never take place. And yet, sadly, when you open a door, it's naive to believe that no one will ever walk through it. In Georgia, a graduate student was expelled from her graduate counseling program because she refused to change her personal beliefs regarding homosexuality. What happens when speaking your personal beliefs become punishable by law? As another example of what could take place under this law, what happens when a lesbian couple proclaims to be offended by a local restaurant because when they walk in, the couple are greeted by the hostess with the common phrase, "Hello, ladies." One of the women could take offense because of a perceived inaccurate gender reference. Under this law, whether the offense is intentional or not, or intentional or perceived, that establishment could face charges. Ladies and gentlemen, as each one of these examples demonstrate, in seeking to right one form of perceived discrimination, and I don't mean to discount the stories that are here today, the door to another form of far-reaching discrimination is sadly opened. And where is the recourse for those individuals who are affected? What about the teenage girl who doesn't appreciate a boy in her locker room? What rights does she have? And is it correct that you vote to take away those rights? What about the family that wants to teach their children or the pastor who wants to define morality for his or her flock? It will be under threat of criminal offense for doing so when the phrase sexual orientation someday is broadened to define all forms of sexual conduct. As we look to the more publicized cases of the florist in Washington or the baker in Oregon or the photographer in New Mexico, was it right for their rights to be superseded? While all along, there were other service providers willing to meet the needs of those couples. Why can't common sense and free exchange in the marketplace provide the solutions here instead of the long arm of government, ensuring that one person wins while the other person loses? When it comes to business, the free market will determine if a business succeeds or fails. When enough people decide to no longer do business with an entity because they disagree intellectually or philosophically with the business owner's policies and practices, the business either changes or it fails. No government coercion was employed. All parties acted in their own perceived best interest. That is the correct way to settle such disagreements. Sadly, proposed laws such as House Bill 2 become legislated one-way streets that codify reverse discrimination. And for what purpose? If this was truly as significant a problem in the state as is purported, wouldn't the papers be filled with accounts? Rather than make into law this severe section of government overreach, isn't it time to first allow the civil rights laws that are in place to protect from discrimination regarding immutable and unchangeable characteristics? Second, allow hate crime laws to protect against violent crimes that are rooted in hate. And third, allow our consciences to govern behavior and attitudes. We know, members of the committee, We cannot legislate kindness. We already have laws on the books to take care of truly unfair treatment. I urge the committee to vote yes for common sense and fairness and no for House Bill 2. Idahoans know how to treat each other with respect and dignity. You've been elected to represent all the state. As you vote, please ensure you do that.
Are there questions?
Thank you.
Thank you, sir. Oh, let's see, where were we? Julie Stratton, followed by Ken Connolly, followed by Emily Jackson Edney. Please
Mr.
state your name.
Chairman.
Please state your name and who you represent.
Thank you. Mr. Chairman and members of the committee, my name is Julie Stratton, and I live in Post Falls. I am here today on behalf of myself and my wife, who is a physician and can't be here with us today, to support HB 2. I am a wife, I am a daughter, I am a sister, I'm a college graduate, I'm a volunteer, a mentor, and a leader in my community. I am so much more than my sexual orientation. My wife, Amy, and I have the same conversations that most every other couple does. We talk about what we're having for dinner and who's going to go to the grocery store. We talk about who's going to walk the dog and who gets to sleep in, who's going to shovel the driveway this time. And we have parties and we have barbecues with our neighbors. We're just like everybody else in that way. We call Idaho our home. We want to be proud of living in this state, and right now we're struggling with that. I want to live in a state that fully values who I am and who will protect Amy and me from discrimination. I want to be evaluated on my job performance, on my commitment to my community, on how I treat my family and my friends, and how I support my local businesses. I want to be valued as a human being based on the person that I am, the person that my mother raised me to be. I want to contribute and not be judged on my sexual orientation and on my gender identity or my gender expression. Passing HB 2 would be a great step in showing me that I have value in this state and that you want me here. Please include my wife and me as full and equal citizens of this state and help us to be proud of living here. I thank you.
Are there questions? Thank you. Ken Connolly, followed by, let's see, Emily Jackson Edney. Let me get one more here on deck as well. Followed by Kent Davis. Please state your name for the record.
Thank you, and good morning, Mr. Chairman and members of the committee. My name is Ken Conley, and I'm legal counsel with Alliance Defending Freedom, which litigates religious liberty cases throughout the country. We are counsel to the Hitching Post in Coeur d'Alene, whose legal dilemma I will discuss later in my remarks. I appreciate the opportunity to speak with you this morning regarding the legal problems and other shortcomings of House Bill 2. Our client, Baronelle Stutzman, is the owner of Arlene's Flowers, a small floral shop in Washington State. For 35 years, she has been a friend and confidant to employees and customers alike. She has helped them through her kindness and creativity to celebrate the good times on the one hand and weather the storms of life on the other. Of course, Baronelle has had designers and friends and customers who are gay, and each one of them has always received the same special treatment that every other customer has received, the type of treatment that has made her the go-to florist for many. One of those customers was named Rob Ingersoll, who Baronelle counted as a friend for some 10 years. In fact, he was such a good friend that Baronelle gave him a hug at a deposition they were both attending. Now, you might be wondering what they were both doing there. Well, when same-sex marriage became legal in Washington, Rob naturally asked Baronelle to prepare the floral arrangements for his wedding. But after much prayerful reflection and discussion with her husband, she told Rob that she was sorry, that she loved him, but she could not arrange the flowers for his wedding because of her Christian conviction that marriage is exclusively the union of one man and one woman. She just could not participate in a union that did not reflect God's design for marriage. Although Rob originally responded graciously and told Barronell that he understood, the couple and the Attorney General of Washington soon thereafter sued Barronell. Despite the fact that the plaintiffs were easily able to find another forest to complete the arrangement, Barronell now stands to lose her business and perhaps even her home if the lawsuit is successful. All Barronell attempted to do was to stand by her religious convictions. But the so-called non-discrimination law, which was billed as a shield to protect others from discrimination, is now being used as a sword to punish her for being faithful to her God. House Bill 2 would do the same. Another client of ours, Blaine Adamson, is the managing owner of Hands On Originals in Lexington, Kentucky. It's a promotional printing shop. He politely declined to print a T-shirt order requested by the Gay and Lesbian Services Organization because, based upon his religious beliefs, he could not promote the message of the organization's Pride Festival. He has hired gay employees and routinely filled orders for customers who are gay or lesbian. In fact, the company has never declined an order based on anyone's sexual orientation or gender identity. But it has declined to print on numerous occasions, just like this one, orders based on the messages contained in the requested shirts, as is its constitutional right. Despite the fact that the JOSO was able to secure their T-shirt order for free from another vendor, the organization sued Blaine and conducted a public media campaign against Hands On Originals, resulting in the loss of significant business to the company. The Human Rights Commission later ruled that Blaine violated the law and ordered him to diversity training, presumably to re-educate him as to the proper way to think. The case is currently on appeal, but the government has no business dictating to a private citizen what he's to believe or not believe. Yet House Bill 2 would do just that. And just in case there's any doubt that it could happen here, as I said, we have the case of the hitching post out of Coeur d'Alene. Don and Lib Knapp are two ordained Christian ministers who have owned and operated the wedding chapel for 25 years. On at least 3 separate occasions, the city made it clear to the Knapps that if they refused to perform a same-sex wedding ceremony, they would be in violation of the non-discrimination law and subject to criminal sanctions, potential jail time, and fines. After politely declining to officiate 2 same-sex ceremonies, the Knapps were left with no choice but to seek a temporary restraining order to prevent the city from prosecuting them for their beliefs. Although the city has since changed its original stance, citizens should not have to file protective lawsuits merely to remain true to their consciences. But House Bill 2, again, would force many businesses to consider doing just that. As an organization, we at the Alliance Defending Freedom represent many other individuals and businesses facing similar persecution. I note for the committee that none of these cases involved a shortage of goods or services. Customers were always able to find an alternate vendor quickly and often at lower or even no cost to them. And each of our clients serve gay and lesbian customers without question. But they cannot participate in events or speak or create messages that violate their sincerely held religious beliefs, no matter what or who requests them to do so. Like the majority of Idahoans and Americans, they merely want to make a living and live a life consistent with their religious beliefs. Yet neither their goodwill nor their service of gay and lesbian customers mattered when the so-called non-discrimination laws came calling. Laws like House Bill 2 present hardworking business owners with an impossible choice. Either reject your faith in your God and bow to the ever-expanding non-discrimination laws, or keep your faith and honor your God, but accept the financial loss, reputational harm, and business damage that is sure to follow. As if this were not enough, House Bill 2 creates an atmosphere of excessive regulation, uncertainty, and impossibly conflicting legal mandates, which in a time of economic uncertainty promises to saddle businesses and the government alike with significant financial burdens. As to the government, House Bill 2 in many applications will violate the free exercise and free speech guarantees of the United States and Idaho constitutions. It will also violate Idaho's FERPA in many applications. The state will have to defend against those legal challenges, which will prove costly and time-consuming. Perhaps most important, the state will have to pay the attorney's fees of each litigant who successfully challenges the law. That could very well reach into hundreds of thousands for each case, further burdening the state treasury. As to businesses, small businesses are the lifeblood of the Idaho economy, and they will be particularly hurt by House Bill 2. The lawsuits I described at the outset are difficult to defend and require substantial time and resources to combat. Time and resources business owners need to devote to actually running their businesses, not to defending against lawsuits. Even a frivolous case against a small business has a potential to financially harm it. But a case in which damages and attorney's fees are awarded against the business would likely prove insurmountable. One of our other clients, Elaine Huguenin, can attest to the toll a law like House Bill 2 can take on a business. Elaine was sued under the New Mexico Human Rights Act for declining to photograph a same-sex commitment ceremony, for simply opting not to use her expressive skills to promote an understanding of marriage that conflicted with her religious beliefs. She had to endure 7 years of protracted litigation, almost a quarter of her life. Needless to say, cases like these hardly stand as a testament to a welcoming business environment. Like other laws that have gone before it, House Bill 2 jeopardizes the fiscal welfare and future existence of wealth-generating businesses in Idaho. And small businesses, it should be noted, are not the only ones in danger of being harmed. Under its plain terms, as best we can tell, after conducting a legal analysis, House Bill 2 could also endanger churches and religious schools, which may be forced to employ clergy, teachers, and employees whose sexual practices or identification conflicts with the organization's faith and doctrine. Similarly, private religious schools may be forced to enroll students whose sexual practices or identifications conflicts with the organization's faith and doctrine. Finally, I would like to briefly mention one other serious problem with House Bill 2. You've heard a little bit about it, but I'd like to take it from a legal perspective. The bill's gender identity component would compromise privacy and safety, as you've heard, and would also put businesses in no-win situations. House Bill 2 will require that public restrooms and locker rooms be gender neutral. With respect to fitness centers and similar entities, that would mean that biological males who identify as women could be showering with your mothers, sisters, wives, and daughters with no advance notice to them. Furthermore, because there is simply no way to police a person's subjective gender identity from one moment or one day to another, there is no way to confine the reach of House Bill 2 to those who sincerely identify as a member of the opposite sex. For example, nothing in House Bill 2 would prevent abuses seen in other jurisdictions where gender identity laws have been used as a ruse by men to enter young girls' and women's restrooms and locker rooms for illicit purposes. In this way, House Bill 2 would also create potentially massive liability for businesses and will place them in an impossible no-win situation. Businesses will have to either comply with House Bill 2 or continue to protect the privacy and safety of their patrons. They cannot do both. If they enforce gender neutrality under House Bill 2, they'll be subject to lawsuits and significant monetary loss if someone is injured or traumatized as a result of their failure to abide by their common law duty of care to employees and patrons. But if they maintain sex-specific facilities, they can be sued and sued civilly for failing to abide by House Bill 2. And once again, the state of Idaho and its Treasury stand to lose as well. Individual third parties offended or negatively affected by having to use a government restroom or locker room facility with a member of the opposite sex can sue the state for violating their constitutional right to privacy. That would expose the state to significant litigation costs and, again, attorney's fee awards. In closing, I would note that tolerance must be a two-way street if it is to mean anything in a pluralistic society. House Bill 2 rejects tolerance in favor of government compulsion and requires Idahoans to sacrifice their conscience as the price of citizenship. In the process, it also has the unintended consequence of imposing onerous and costly regulations that will damage both small businesses and the state treasury. That is not the freedom contemplated by either the United States or Idaho constitutions, and it's not the freedom each member of this committee is sworn to uphold. Thank you.
Are there questions? Representative Crane.
Thank you, Mr. Chairman, and I'm sorry, sir, I didn't catch your name, but I had a couple of questions for you. First of all, you listed a series of lawsuits that have taken place across the country or in the Northwest. Did those states in which your clients had suits brought against them, did they have this particular statute or these words added to their Human Rights Act?
Yes, it was a statute much like it. So these cases are the type of things you will expect to see if these words are put in if these protected classes are added in.
Follow up, Mr. Chairman.
Representative Crane.
Thank you, Mr. Chairman. And sir, well, one of the things that has struck me is the concern out there of individuals that feel like that they are being discriminated against. And one of the reasons they're asking for passage is so that there will not be discrimination against these individuals for their sexual orientation or their gender identity. So if those laws are in effect in those states, then why are they still continuing to sue?
Mr. Connolly.
Thank you, Mr. Chairman. Why are they? Well, because what happens, Representative Crane, is that the types of businesses that are affected by these laws, and the types I'm speaking about, event services businesses, people who are in business who might spread or create message-type activities. The reason they're suing is because these people are declining service based on their First Amendment rights. So the First Amendment protects these businesses. But what happens is these laws, in effect, turn the tables on the businesses. They have to go into court under the Human Rights Commission and defend their First Amendment rights. In other words, the First Amendment and the Supremacy Clause of the United States Constitution should control here. They shouldn't have to, as a matter of course, defend themselves as a matter of course by the Human Rights Commission, if that makes sense. In other words, the default is that the business does not have to print any message it does not want to print. But what the Human Rights Commission's laws, and much like House Bill 2 would do, is it operates to give a person who doesn't agree with that First Amendment right the opportunity to haul somebody into court and then have them on the defensive. And that's where the business climate suffers, because they have to then defend themselves when, as a matter of course, they already have that right.
Follow, Mr. Chairman?
Representative Crane.
So then at that point, isn't the individual discriminating against the business owner's right to uphold their sincerely held religious beliefs?
Well, and you've heard, thank you, Mr. Chairman. Yes, Representative Crater, you've heard a little bit about this with the idea of reverse discrimination. What these laws enable plaintiffs to do is it enables them to turn the tables, right? So they are then able to say, I don't like your religious expression, I don't like your religious rights, I don't really much care for your freedom of expression. We have a protected class here, and you will abide by the protected class. Now, the way it should work out right away in any court of law is that the Supremacy Clause in the First Amendment wins out. That's the law. But what happens is, in many of these cases, the local ordinance keeps these people in court. As I said, our client was kept in court for 7 years. Our client in Lexington, Kentucky is 3 years into it, and we're only at the circuit court right now.
Final question, Mr. Chairman.
Representative Crane.
Thank you, Mr. Chairman. Sir, so I've heard testimony today, however, that religious institutions would be protected and would be exempt from this, or people that have religious beliefs would be exempt. So are you saying you disagree with that testimony?
Mr. Connolly.
Thank you, Mr. Chairman. Yes, I am, Representative Crane. If you look at the actual text of the bill, what it does is it enables religious organizations and churches to make hiring decisions based on religion. So in other words, you can hire somebody, a Baptist church would not have to hire a Lutheran. They could preference a Baptist. However, it makes no particular provision for beliefs. So in other words, as the client of ours, if we represented a Catholic school in New York City, where a music teacher decided one day that he was no longer a man. He was going to identify as a woman. They were sued, despite the fact that Catholic sexual morality teaching was that was against Catholic teaching. And as a matter of course, they wouldn't have had to hire him to begin with. But once he decided to identify as a woman, they were sued under the local non-discrimination law. So if, say, for instance, like the Baptist church I just gave you the example, if they get an application from a gay or lesbian Baptist and they say, I'm sorry, that's against our particular religious beliefs, this bill doesn't protect that. He's still a Baptist. It only protects co-religionists. So there's a real problem with that. It's much more complicated than it's being presented.
Further questions? Hearing none, thank you, sir.